Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk, Chris, and Ted's Excellent Adventure Call-In Show Live. Welcome, Kirk. How are you?
I'm doing great, Ted. How are you? And Chris, how are you?
I'm awesome, good. Guys. How are you guys doing tonight?
Fantastic.
Well, let's get this. We get this show on the road since we're running a little late tonight.
So you're probably wondering why we all gathered here today. We're in the peanut gallery. So this is a call-in show, but there's a couple things I'd like to bring to attention. Breaking news for those of you are aware or not aware. The Bundy trial down in Nevada. Word from John Lamb live.
Got an echo on. Is that
not for me?
Not me.
That's
how about better. Now?
Much better.
Yeah. I just muted Chris. Sorry, Chris. The judge has basically said, we're releasing Ammon Bundy, Ryan Payne.
That's incredible.
Things are changing. This is federal court, people. These people have been incarcerated for 2 years in prison, not county jail. We're talking prison for basically rebellion, falling under the Patriot Act, treasonous. This is like treasonous acts that they're being accused of, conspiring to overthrow the government type stuff. And it's been a battle, but you know, a few of the Idaho people that went down there, 3% of Idaho went down there, and they, you know, obviously they got charged and sucked into this, but this was back in 2014, and they didn't do anything about it until after what happened over there in Burns at the Malheur Wildlife Refuge, and they stood up to them over there, FBI, BLM, where they killed Lavoy Finicum. Okay, it went to trial over there, and they were all found not guilty. So at the end of that trial, boom, not guilty. All of a sudden, here's these black coats. They attacked these people in court right in front of the judge right after it was not guilty, because that means you're immediately released. You can't take them back to prison and then release them from there. When you're found not guilty, you walk free from right there. Okay? So these black coats were there knowing that, you know, the way the trial went, that they'd lost bad. They couldn't prove jack anyway. So the lead attorney there for Ammon Bundy said, all right, where's your paperwork? Where's your warrant? Got to have a warrant. And looked at the judge and said, I'm demanding their paperwork. And what do? They jumped this attorney, tased him like 3 different times, tackled him to the floor, and arrested him. Basically for obstruction of justice, but where's your warrant? So this is the evil that I'm fully aware of, the corruption in our country and around the world. Trust me. I may not know every single piece of it, but like I said, I've been at this for over 20 years, since 1995. Plus, I was the child back in 1985 that was stolen by CPS. So I'm aware of the corruption. I really am. So I want to put this hope out there to you because of what Jeff Sessions has done, and the fact that we had pretty much every single representative from the state of Idaho sign a letter to Jeff Sessions, the Attorney General for the United States of America, saying, look, there's some stuff going on down here in this trial. It's unconstitutional. and you're the lead attorney for the United States of America, and this is your jurisdiction because this is a federal court. These people have been imprisoned unlawfully. Even under the Patriot Act, you know, that particular part's unlawful because you really don't have the right to a cause of action here. They already proved that at the other trial and was acquitted. They were found not guilty. So this is going back to part of the change that Chris Hallett and Ted and I had put out here with the breaking news last week was, you know, the rule of law is coming back. And so, you know, with Ryan Bundy, he basically, in the first set of trials, okay, there's like 3 tiers here. The lower tier, tier 3, at first, the first trial, they had to take him twice, and they still couldn't get him convicted. The court watchers, the public, was not allowed to have a pocket constitution in their pocket. The second trial, it was, okay, you can have the pocket constitution, but you can't have it facing with Lavoy Finicum's face on it because you didn't want the jury to see that picture. Well, okay. Now we go to the second tier, and they're starting that trial stuff. And Ryan Bundy's now allowed to actually break out his constitution and read from it to the jury. Okay. In the first trial and the second trial, the judge was flat out saying, you can't even bring up the Constitution. Oh, really? By what authority? So this is the hope I'm trying to put out there to you folks, is that, sorry, caller, go ahead and call back. I just wanted to get this breaking news out that, you know, this is giving hope to the people because this is the rule of law that Jeff Sessions is putting the smackdown on. The law says this is the law, the Constitution. It's the supreme law of the land. And under property, our rights are our property, including the Constitution. That's our property. That's us. That belongs to us. Declaration of Independence, that's our property. Our rights are our property. Look up property in Black's Law Dictionary. It's what it says. So, you know, being allowed to read the Constitution to the jury in court, yeah. So that's, you know, that's basically what I've got there. And things are changing. Like, I mean, why is all of a sudden the judge allowing people to read the Constitution aloud in court on the record to the jury? Why is all of a sudden the judge going, okay, we're gonna do pretrial release on these guys? Because pressure, the people spoke, and more specifically, almost all of the representatives of the state of Idaho signed that letter to Jeff Sessions. And so this is what I'm trying to get, you know, out there to you folks. Education. Get in touch with your representatives. Let them know what's going on because they don't know. I can tell you. I can tell you they don't know. So unless we tell them and inform them, and again, this is where I go back to treating the people like a man. Treat them like you would want to be treated. Okay. When you go to talk to somebody, don't go half-cocked and emotional and act out in rage. I know those feelings. Trust me. Anger is a healthy emotion, just like happiness. You know, we wouldn't know what happiness was if we didn't have sadness or anger. Okay, so I'm not denying you your anger and your rage, your frustration. I go through it myself. Trust me. Some of you have seen it on here. Okay, I'm a human being just like everybody else. But when you go to talk to somebody and you want to get your thoughts and ideas heard, and whatever it is you want to be heard, it would behoove us to talk to these people with dignity and respect as a human being. They may not be the enemy. They just might not be. So when you go to talk to them, you know, here's the law, sir, ma'am, here's the law. This is what it says. Oh, wow, you're right. What did you say was going on down there? Well, this is what's happening. This is what I've witnessed. So initially when this started out, a couple of the representatives went down there and they sat in on a couple of the hearings and they said, no. Here's the law. You can't do that. I know that. So they came back and they went in and had conversations with the other representatives and started contacting each other, email, talking to each other, and said, hey, you guys know what's going on down here in Nevada? We've got Idahoans that went down in Nevada in 2014 and, exercised their Second Amendment right to keep and bear arms, and then helped defend Cliven Bundy and the Bundy Ranch from this hostile takeover. Did you know that there was snipers all the way up around on the ridges before they even started to go down there? Did you know that the sheriff told them to get the heck out of there already prior to these people coming to get their cattle? Because that's what they thought they were doing. And when they showed up on horseback to go get their cattle, they were met with all these armed people that were already told to be gone by the sheriff. You were already told to be gone. What are you still doing here? So, I'm trying to put this hope out there, folks, that there's a change. The rule of law is coming back. I don't care if you like Trump or not. If you're buying into the mainstream media BS, just so you know, that's all propaganda. Something I mentioned earlier today on Francesca's show. Are you aware that they actually created statutory law, congressional act, that they can kill people to create this propaganda? That's pretty sad, ain't it? Making murder legal. So when you see breaking news on TV, okay, I think it's like 116 mainstream media outlets are all owned by 9 people. Think about that for a minute. 9 people own and operate the 116 plus or minus, I don't know. Last I knew it was 116 mainstream media outlets are controlled by these 9 people. They're told what to say. And, somebody says something a little off and goes outside of their duties they're supposed to perform working for the mainstream media, they get fired or killed. And it's happened. Okay. So, look at Judge Scalia. Or how do you say his name again? Yeah. Scalia. There it is. He was murdered. Sitting in, this is the evil we're up against. This is what we're up against. And, again, things are changing. I want to put the hope out there. We're going to have to stand. And I don't want to say I want to be murdered, but I'm willing to make that risk. That's what I'm doing. I'm putting my neck on the line here to educate you guys on what the law says. And I'm making a stand here in Idaho. And that's what I want you folks to do. Make a stand. But you got to know what the law says to make a stand, because if you don't know what it says, most of the patriots that went down there to the Bundy stuff, the Bundy Ranch, already carried constitutions. They already knew the Constitution. They already knew the law for the most part. The same ones that went over there into Oregon, they had constitutions with them. They knew what the Constitution was. They knew what they were doing was lawful. And that's why they didn't lose in court. They were acquitted because they acted lawfully. All they did was exercise their rights. Okay? The claim and exercise of a right cannot be converted into a crime. That's Miller versus U.S. And that's why we have the right to a trial by jury, not a trial by judge. The judge is just supposed to be a referee judging facts of law. Well, Judge, judicial notice, the law says this. Yep, Mr. Pendergrass, you're absolutely right. That's the judge's duty. That's it. That's his only duty. He does not have the power to act like a juror. He doesn't have the power to act like a prosecutor and ask discovery questions, ask you to provide evidence. No, that's not within their scope and moral duties and ethical obligations under the law. That's not what we created that position for. Remember, we, the people, are self-governed. We created government. Government doesn't exist unless we put it down on paper and create it. So for those of you that think that the Constitution is just an old document, which is what they're teaching in school now, oh, that's just an old document, or it's a living document. It can be changed. We can just statutorily do whatever we want. No. That's our form of government. What's the very first words of the Constitution of the United States of America? We the people, in the preamble. This is by authority of and consent of the people. We consent to be governed this way. And that's why you need to know what this says, so that you can read it aloud in court. Thank God we can read it in court now. So again, hope. So tonight, we do Law for Dummies on Monday nights, and the following has gotten so big since we've gone live on Kirk's Law Corner, the Marches, YouTube, Twitter, and all this stuff. It's blown up. Okay, so my vision for doing what I started, Kirk's Law Corner, was to educate the people on law. So that's what Law for Dummies is about. What this actually says. Learn what it says, and I'm going to go through it and explain things and that kind of stuff. And there's a call for the calls. People want to call in. People want to talk about their case. People want help with their case. Well, that's a little difficult to do because, one, I'm not an attorney. I can't give you legal advice. But here is what I'm going to say. I can speak the law. I can read the rules of procedure to you. I can, to be honest, I'm not really afraid of this. You have to have a license to practice law. Really? This is my property. I don't have to have your permission or anybody else's permission to speak the law. That's like saying, you bring your car to me at mechanic shop, and you're going to tell me I can't talk about how to fix your car with other people, whether I'm being paid to do that or not. No, this is mine. This is my property, and you're trespassing upon my property and depriving me of my freedom of speech to speak the law. So, again, call-in show tonight. So let's bring Chris on, see if we get rid of the echo there.
Is there an echo?
Can you hear
the
Chris?
echo?
No, we're good.
Can you hear me?
Yep.
Okay. All right. So what do we do? We had a caller and they instantly hung up. So apologize for that. But Chris, would you like to say anything? Talk about what we're doing?
Yeah, basically while we're killing time. I mean, what you were just talking about, what Sessions did in killing the guidance documents and their quote unquote fictitious authority. He upheld the rule of law, and whether he heard it from us on our show or whether the reality hit him in the face or whatever the hell happened, it doesn't matter to me. But he realized that those guidance documents were nothing more than bills of attainder with a different name on them. It is what it is. So, it's what you were saying about having to have a license to practice law. Well, that's relitigating the Cindy Ahern case. And that case basically said that there is no license to practice law. You can license a business, but you can't license the practice. So, ironically, I'm working an interesting case with that right now. So, just did my notice of appearance this afternoon. So we're going to see how that's going to turn out.
Nice. I've taken some time and finally read some of your paperwork. Beautiful stuff. And like I did read some of it before, and that's one reason why I hooked up with you, because you have a brilliant mind. You're the like-minded kind of person. There's stuff that I know that you don't know, and there's definitely stuff that you know that I don't know. And that's why we work well together. Getting that echo again. So we do have a caller here, and let's bring them on and let's see What kind of question we got here? 9138. You're live with Kirk, Chris, and Ted's Excellent Adventures call-in show. What is your question? Who we talking to?
Hey, how you guys doing? Kurt, Chris, and what is it? EdX
Ted.
Adventures?
Ted.
Like Bill and Ted's Excellent Adventure?
Yeah, my name's Ted.
Oh,
so
okay.
I
Bill,
always get stuck with that.
Bill, how you doing, buddy?
Where there's not even a Bill.
There's no Bill. You got Kirk, Chris, and Ted.
We'll just rename.
All right, Kurt. Kurt, Captain Kirk, Chris, and Ted. All right.
There you go. Slavin really pushed that nickname on you.
How you guys doing tonight? I listened to your show. Yeah, I mean, the thing is, I mean, what you're doing is awesome. It's just that I've been in family court. I just had if you want to call it a trial, finish Monday after being dragged out for 6 years, a custody trial, and it was the most horrible experience I've ever been through.
Right.
And it's not nowhere near over. I've tried to claim constitutional rights and in the courtroom and basically do what you said, and I was, bullied by the judge, told to shut up.
Mm-hmm.
The lower courts.
Put in jail for 60 days. Mike Volpe did an article on it. He put it in the newspaper. It was on some radio shows. They forced me to use an attorney, saying because I spoke out in the courtroom and quoted the Constitution and tried to say, look, I have rights. I'm a person. I want to speak. I know the truth.
Yeah.
Even the lawyer, after getting to know me, he said, look, I'll he saw what I was going through. He just said, he said, I'll be a consultant for procedure and you can represent yourself. Let's see if you can do it. And he wouldn't let me represent myself. He was protecting me from myself.
Right.
They said, I don't know. I don't think you fully understand what's at stake here. You could lose custody of your child. I'm like, I don't understand what's at, I'm just like, listen, you start like almost going deaf.
Right. So this is the thing that we need to understand about attorneys is, again, attorneys are to attorn you. That's the root word of attorney. So to attorn is to take your stuff, your property, your rights, and give them to somebody else. And the first thing an attorney does is they do a notice of appearance, okay, on your behalf, and they admit the jurisdiction. And then they take leave, which means I'm here to admit the jurisdiction. I'm representing this person, but I'm going to take leave so that anything and everything that happens from here on out happens to this guy over here and not me. That's the duty of the attorney, and it's part of the scam, the racketeering scheme, the emoluments violations that Chris is attacking. The fact that they're being paid. You hire them. You pay them to, in your mind, you're hiring them to defend your rights, to speak on your behalf. But that's not the case. Under their membership to the club, and as an officer of the court, their first duty and allegiance is to the court, to follow statutory law and their rules of procedure.
Their bills of attainder.
Constitution. And then to the people of the state. Okay? Not to you. And that's wrong. That's an unjust enrichment. Okay? So we understand what this gentleman goes through all the time. We've heard it. I've heard it. I've been, and this is, again, this isn't just family law. I'm telling you, it's not just family.
No, I get it. I mean, when.
Okay, so, I've been through criminal court. It's the same treatment. Trust me. I was treated the same way. Well, we've been doing it like this for 95 years. Are you accusing me of crime? Well,
yep.
Not at this particular point, but you know what? have gotten a little bit older and got some more hair on my balls, I tell you what, yes, I am accusing you of a crime, and in fact, it's a felony under Title 18, Section 241 or 242 or 643, whichever one I decide to throw at you. But all three of those are a felony, and I have the power to make an arrest right here, right now, because you just admitted it in open court and on the record. You are depriving me of my right to speak the law. Ready to go to prison, Judge? Ready to go to prison, Miss Prosecutor? Yeah. That's what I'm talking about. You have to get to the point where you know what your rights are, because they will literally empower you, just like it has me. You wonder why I'm able to rattle this stuff off. It's because I read it. I know what it says. I know what my rights are. So I know when somebody is depriving me of a right. Okay? So this is the education we try to put out, is knowing what your rights are, where they come from in law, which we show you. We tell you what it is. We tell you where to go to find exactly what we're reading. We tell you what we're reading from. So you know, we can't. It's like, okay, here's an analogy for you. You want to know how to run a lawnmower. I can tell you how to check the oil. I can tell you how to put gas in it. I can tell you how to prime it. I can tell you to put the choke on. And I can tell you how to start it. And then once it gets started, you pull it off a choke and you mow your lawn. Now, that's all the further I can go. I can't come over to your house and mow your lawn for you, because that's not teaching you how to mow your lawn.
All right, Kurt, I got a quick question for you.
How to mow your lawn, not mow your lawn for you.
All right, I got a quick question for you.
Okay.
You there? Okay. All right. I don't know how it is in Idaho. I used to live in Oregon, but I've never been to court in Oregon. I'm 47 years old. I've been to court for little things, but I don't even have a misdemeanor on my record. I'm pretty much a law-abiding citizen, but I've been put in jail because when I'm just going to give you a briefing of what it is. This is the seventh judge, because judges just recused themselves in this case, because I've done what you're saying. I've said this is not, how can you do this? You know, it says right here, the Supreme Court of the United States has declared narrowly construed the right to raise your child as under liberty. It's right here. And I mean, you say this star justice or whatever, it doesn't make sense. No, that's not the law, which I understand, but interpreting the law, they said that that's one of the oldest that's one of the oldest understood facts of the laws of nature, is that, you know, you have the right to raise your children.
Right. So
I'll give you those children, not the judge or the state.
I mean, that child was born to me. I had custodial rights.
Okay. Knowing where your rights come from dictate the proper jurisdiction. So parental rights come from the Declaration of Independence and protected by the Ninth Amendment. Okay. Other rights retained by the people shall not be denied or disparaged. That's what the Ninth Amendment says. Okay. So parental rights and marital rights are fundamental, unalienable, creator-endowed rights from the common law. So this is why we have to make our motions for dismissal and claim lack of jurisdiction, personal jurisdiction. Now, I know there's people out there, well, this, you know, I've tried that doesn't work. And I ask them, okay, did you do your notice of a special appearance? Did you file your affidavit of status? Well, no. Did you file the motion to, you know, demand the hearing? Did you file your brief and memorandum of law? Well, no. Well, then you didn't follow due process of law. You have to follow due process of law. That's just the way it works. You know, back to going into grade school, you know, we were taught to raise our hand if you want to be heard. Okay. When you go to court, the proper way to raise your hand is by filing paperwork, a notice of hearing. And you have to do the motion. What motion practice is you have to read your rules of procedure. And you say, oh, comes now so-and-so under pursuant to rule blah, 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 blah. And you have to write your rule that you're pursuant to, which gives the court jurisdiction to hear you, to call on you. So when you raise your hand, the judge can call on you, go, okay, I'm putting this hat on because we're hearing this subject matter right here. So whatever it is, the rule of procedure that you quote in your motion is what the subject matter of that hearing is going to be. And you have to stick to that subject matter. You can't bring up other stuff that's outside of that subject matter for that hearing. So again, got to raise your hand in order to be heard. Now, I know about the corruption. I know about the total, well, we can't even talk about the Constitution, blah, 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 blah. Make your statements. I don't care. Let that judge put it on the record that they're denying you to speak the law. And then what happens is you have the right to appeal that decision. Your right to due process of law doesn't stop right there. Just because that, and actually most of these, the first ones we go into, are not judges, okay? That's the thing we need to understand. They're not judges. They're commissioners or magistrates, okay? They're administrators. They're there to administrate a hearing. This is why I go back to sui juris. Sui juris means that you're of lawful age, 21. You're of sound mind, and you have the ability to take care of your administrative duties under the law. This is due process of law. You have to exercise your right. I can't do it for you. Chris can't do it for you. Ted can't do it for you. You have to do it. That's why we're here. We're here to educate you on this process.
Well, and to basically sum that up in kind of a shorter answer, my favorite explanation of this is nobody knows your case better than you do. You're the one who knows where all these little subtle nuances came in. You're the one who, whether you realize it or not, remembers that, oh, that's right, that was on February 11th. Or, yeah, that thing happened, it was on June 9th. There's no way anybody could know that stuff but you. And one of the things that, that makes this, that'll separate you from the rest is not just knowing what the law says, but understanding that process. And that process is ridiculously overly burdensome. Don't let anybody kid you. I mean, the rules of procedure in the state of Florida alone are more than 700 pages. Now you're going to tell me that that's reasonable? No. So, right. The law is written very clearly, but the rules of procedure, this one means this, but it also could be this, or this, and this cancels out this over here. And if this happened on the second Tuesday of the full moon of January, it's like, are you kidding me? Really? And, no, that's the way a lot of that.
No, all right. So you're saying, Kurt.
Yeah. So,
Kurt, you said that we're here to teach you procedure. Okay? Is that what you said?
Well, we can teach you what the law says and where to go find it.
No, that's not what Kurt said. We're here to teach you procedure. Because, like you said, just the statutes, the procedures in the state, the rules of the court.
I can tell you where to go in your, okay, you're in your state. Okay.
I've been to the appellate division on several different issues.
Mm-hmm.
And then I've been to the Court of Appeals, to the highest court in the state of New York.
Well, the highest court would be the Supreme Court.
Court of Appeals.
No, not in New York. No, in New York, it's the Court of Appeals is the highest. The appellate division, there's 4 appellate divisions. You have the Supreme Court, which is the county court or the city court. Then you have the four appellate courts. Then you have the Court of Appeals, which is the highest court in the state of New York.
No.
Then you have your federal district.
You're supposed to have it.
No, it's not wrong. Look up the state of New York. Look up the state of New York. Go to Google. Go to Google Scholar and look it up. And every other state,
that's not
the
our
Supreme Court
American
is the highest.
system of jurisprudence. I mean, it's a
telling you, in the
three-tier
state of New
process,
York,
whether it's state or federal. You've got your district court where your proceeding happens. Then you have your appellate court, and then you have your state Supreme Court. Yes. It's the exact same thing in state as it is in federal. If somebody's telling you it's not that way, they're misguiding you. And that goes back to these guidance documents that we were laughing at and saying how ridiculous and all of that crap is. If a state is acting outside of the established rules of jurisprudence, they're not eligible for federal funding. I mean, that's one of the arguments that Trump is having with each and every state, with the sanctuary cities and with this and with that and the blah, 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 blah. You have to comply with the minimum standard. That's what the Republic is all about, So anyway, that just that kind of threw me off a little bit. But anyway, continue.
Let me add to that, because our form of government is laid down in the supreme law of the land. Now, when a state goes to join the union, they have to agree to this, right? Because this is the supreme law of the land.
Right.
You're accepted into the union. Okay.
Right.
Now, that's what is meant by the supreme law of the land. And that's why it says, if anything in the Constitution or the laws of a state to the contrary is notwithstanding in law. Okay. Our form of government has 3 branches of government. All judicial power is vested in one Supreme Court. And the way it's laid out is magistrate, then you have the Supreme Court. And in the Supreme Court, you have the appellate division and the Supreme Court of the state. It has
Technically speaking, it's 4 branches, but because you forgot the people. The people are the largest branch.
The people are the legislative branch. We're the first branch of government.
Correct. Congress is not the first branch. Congress is the second branch. Congress is our representatives, the people we elected to go do that job. Because, like you said, you're fixing cars, I'm doing what I'm doing, et cetera, et cetera, et cetera.
They're not supposed to be doing anything out there on their own.
Correct.
They're supposed to be representing us. Just like that attorney, when you hire an attorney and they don't actually represent you.
Correct.
Their allegiance is an officer of the court and That's what I'm talking about.
Out of 514 members of Congress, at last count, 509 of them were members of, say it with me, the bar. There it is. And the bar is what? A foreign entity. Because it is only a private club, right? It's the fraternity. I mean, you're going to hear it called so many different things. It's actually hysterical, but it's.
But see, this is part of understanding our form of government. Okay. So,
correct.
Brenda keeps talking about this. Well, about the appeal stuff. I'm trying to get to that, Brenda. So when you do take something to the appellate court and you're denied, guess what? What is your next step? That's the question. What do you do?
Certiorari the Supreme Court
of habeas corpus. You are being denied. If you're being deprived of any of your constitutionally protected rights, aside from going Title 42, 1983, and suing civilly and claiming tort claims, which is Title 18, crimes and punishments, that's your tort claims. Okay, they get adjudicated together for damages. Then it's supposed to go to the Attorney General, and they're supposed to be prosecuted for the crimes that you've been awarded damages for. Because that's what the Attorney General's job is, to go after the people who have committed crimes that you've been awarded damages for. That's what Attorney General is for. But writ of habeas corpus, okay? Another one, writ of quo warranto. By what warrant or by what authority are you acting? Now, again, I want everybody out there to understand the change, okay? It's coming. The rule of laws, it's being smacked down, seriously. So forget all this corruption and crap that you have been through and all the denials and the deprivation of rights, you know, your right to due process, your right to be heard and stuff. That's coming to an end, and it's happening real quick. Okay? I'm seeing it firsthand.
Yeah.
Right?
Well, the bills of attainder, those are gone, right?
They're supposed to have been. They've been prohibited a long time ago. So traffic tickets, those are bills of attainder. Those are bills of pains and penalty. That's legislation.
Oh, I'm talking about I was making a funny about the guidance documents.
New York is pretty strange.
Bills of attainder they don't discriminate. That could be statutory law, because statutory law is not law. This is law. Right here. Declaration of Rights, Bills of Rights, Declaration of Independence, constitutions. That's law. The statutory law, and I know this sounds odd, but it's not even supposed to be allowed. That's part of parliamentary practices.
Right. That was what we were battling on Monday night, which was kind of funny because that shows the conflict that everybody's having. That's one of the reasons we have those conflicts, because it's like, you know, we're embattled over the same thing, you know, and it cracks me up, but it is what it is.
Well, yeah, we actually have fun doing this, folks. Really, we do.
Oh yeah, we do.
Hey,
I'm very passionate about the law. So is Chris.
Oh, no, I'm passionate about liberty, man.
I don't know how that keeps happening.
There is something weird about New York. I'll transition myself into the show.
Right.
So looking, obviously in Syracuse, there's the United States Federal Appellate Court. That's the highest, and that's being in Vermont. That's where I'd have to go, is to Syracuse, even though Bangor, Maine is closer. But looking at the court,
federal.
Right. But looking at the court structure, like you said, and what was your name again?
The guy keeps muting me, man, every time I open my mouth.
You're trying to talk over the top of us, and I'm running the show over here. This is my show, not your show. That's how this works.
You said call in. You said call in and talk, and then every time somebody
it's got a weird algorithm.
No.
Zoom has a weird algorithm where the callers, the algorithm will take the caller's voice and put it in priority over the hosts. It's just this weird thing, so it's almost impossible unless we mute the callers. I do it all the time on my show. So I'm looking at the court structure in New York, and like Richmond County Supreme Court, Monroe County Supreme Court, and then in Albany there are appellate courts, like higher appellate courts. So I don't even see a Supreme Court below the United States Court of Appeals. All I see are our county Supreme Courts, and then the New York State, not the New York State, but I see Appeals Court, New York State Appeals Court, and then the U.S. Federal Appeals. It's really strange. I can't find a state superior court in New York. So New York is weird.
I was just explaining that.
So
I was just explaining, in New York you have the county court is called the Supreme Court. So every county in the state of New York, it's called Supreme. Then you have 4 appellate divisions.
Above that.
First, second, third, and fourth. And then you have the Court of Appeals, which is the highest in New York. And the guy that was just there was telling me no.
A lot of people in New York
and I got muted.
A lot of people in New York say
I said it's the only state that does that, I believe.
I think you're correct, because I can't. I'm finding exactly what you're saying, and if you look, New York to some people is like the worst state, and in many different reasons, it is one of the 3.
It's horrible. I'm telling you, I was incarcerated for trying to. asked
Texas
this doing
is,
legal. What I read was completely legal.
So Texas is the number one state that receives incentives, and then California, Florida, and New York are second place in the amount of incentives taken in. And the way people talk about New York and what he just said, and the way it looks like it's set up, it's pretty wacky. I wonder if Francesca...
Yeah, and if it's not, and if it's an appeal, if you appeal something like a...
I mean, look, we got Peter out of New York, for instance.
We got what?
I'm sorry?
Peter was a judge in New York. Or is a judge
Peter
in New
who?
York. A guy who called in the other day, and he's telling us about how parens parenti goes above the Constitution, and that's how they control us. So if he's a bar attorney in New York talking this craziness, you're in New York, I can see how freaking crazy it is in New York.
Oh,
Seems
dude, you have no idea. If you open your mouth and you're not an attorney, it's just like you're right to freedom of speech in the most critical situation,
right?
Where your freedom, you're going to be incarcerated. You're going to lose custody of your child. That they gag you and say if you talk, you're not allowed to talk. You have an attorney. Oh, you want to represent yourself? Oh, you must be crazy. We're going to force you to use an attorney.
Yeah, between
and
what you're
when you
telling
lose,
us,
we're going to make you pay the opposing counsel's attorney fees.
Mm-hmm. Between
you
what
couldn't afford. That's the article Mike Volpe wrote.
That
you
sure
guys know who Mike Volpe is?
Power. It sure sounds like treason. This is
Yeah,
part,
I mean,
you're aware. Okay, you're aware of what's going on there. We're actually trying to teach you what the law actually says, so you know what's wrong.
I got a constitution right in front of me. I know what the law says.
This is the reason why I mute you, because you're not listening. You don't get to talk over me. Okay, people, this is my show. This is our show. You don't get to talk over us. That's how it works. So we're trying to teach you what the law actually says so that you know what's wrong. So I'm telling you, that's what I'm trying to educate you, is 3 branches of government, and inside the judicial branch, you're supposed to have a Supreme Court, the appellate court, and the district court. That's how our law works. That's our form of government. And that's why it says in Article 4, Section 4, guaranteed a Republican form of government to every state. Okay? So you in New York, what you need to do is you need to get with your representatives and you need to grab the Constitution for the United States of America and you say, wait a minute, New York is not in line with the Constitution of the United States of America. This is fraud upon the people. This is capital felony treason. This needs fixed, and it needs fixed right now because this is in violation of due process of law. This is in violation of the Constitution. Okay? This is what we're trying to teach. Your remedies, not just to go to court, how to get a hold of your representatives and change this stuff, because I can guarantee you your state constitution is probably going to lay that out there. Or what you really want to get a hold of is the organic constitution. Okay? Your organic constitution is the one that they submitted to be approved to join the union. And if anything in your constitution, current constitution, is outside of that organic constitution, you can bust them on that. And it has to be in line with the supreme law of the land. Okay? So we have another caller here. Darren, let me unmute you here. Whoops. Come on. I hate when it does that.
I can unmute myself here. How's it going, guys? Can you hear me?
I can hear you.
Yes. All right, Darren, we got you. It keeps changing around. When I go to click on something, it moves.
I've been doing lots of different research and following, kind of what you're doing, and I've kind of been led into a different direction. But I just have one question, and what you guys think about Article 1, Section 8, Clause 17 of the Constitution that you're discussing today, regarding the jurisdiction of any of the courts. If you're going to be held to U.S. law, that Article 1, Section 817 says that if you're on their land and you're committing a crime or doing something on their land, they have jurisdiction. But if you're not on their land and they don't have any evidence to prove that you're on their land, there goes their jurisdiction and they have no case.
Yes, and that's exactly what these patriots are talking about. And that was one of the main arguments is, Article 1, Section 8. Section 8 actually is the delegations of power, not limitations, but delegations of power. Okay, we got another caller. I'm bringing you on. I'm going to put you on mute. Hold on. Okay, so I think that one's Crystal. Okay, Crystal, I'm bringing you on. I'll put you on mute.
I'll unmute myself, Kirk, there.
Yeah, like.
So, here, we'll just do this.
I'm looking at New Hampshire compared to New York.
So,
and obviously there's the Supreme Court of New Hampshire right there in Concord, right?
Now, where the heck is that coming from?
Not me. I don't know where that. It's somebody's feedback.
Everybody is muted, except for me.
Okay. I'm not. You might have me muted, but people can still hear me. Can you hear me? No. So, New Hampshire has the Supreme Court of New Hampshire. New York does not have a Supreme Court of New York, like that guy whose name I forgot was saying.
Okay, I'm unmuted again somehow here.
No, I just unmuted. I'm trying to mute also.
And
okay, let's try that again. I have no idea where that was coming from.
Yeah.
So Article 1, Section 8 is in the Constitution is the delegations of authority, and one of the first ones is commerce between foreign countries and the United States, and foreign countries and the individual states. That's it. That is the proper delegation of authority. Now, Clause 17 talks about land that can be purchased by the federal government, which is outside of my thought process here, because I thought we the people. So how do we take our land that we already own and take our tax dollars that we pay the federal government, okay, to buy our own land from us to, this is just weird. And you have to have the approval, okay, by the legislature of the state, Congress, has to approve the purchase. And then it has to be for the use of, so its intended purpose for buying this land is supposed to be for military purposes, for the protection of our country from foreign invasion. Forts, ports, magazines, and arsenals and other needful buildings for military purposes. Okay, that's the only power we delegated to the federal government is military purposes. Okay, commerce, things out on that. This is where admiralty and maritime law come into play. That's been delegated to the federal government. Article 3, Section 2. Suits at law, suits of equity is for the states. That's our common law, suits at the common law. Okay. Suits in real estate. That's what equities, equitable interest. That's estate, real estate. Then you have admiralty jurisdiction and maritime law. Those go together under federal government because that's the power that we delegated to them to handle all things foreign, out on the sea. The law of contracts, that's maritime law. Contracts, what they've tied us all into, and this is why rights cannot be converted into a privilege, licensed and attached a fee to it. Because you can't convert a right. You can't take my right. That's my property. I own that, not you. That's why we're, you know, a constitutional republic by the public. We're self-governed. All right, De'Aaron, where are you again? Where'd you go? There you are. Unmute.
Okay.
Okay, you're back.
I got a couple things to interject here, just for thoughts, not trying to argue or make a quarrel here. But Article 1, Section 8, you said basically is commercial. Okay, it regulates commerce and contractual relations.
Just one part. I think
okay,
it's
hold on. Now let me finish my statement, and then we'll discuss it. Okay, commerce deals with contracts. Okay. Now, when you go into their court and you ask them, basically, you bring something in front of them and you say, I'm trying to get custody, I'm trying to work this out. You're basically contracting with these courts. And so they don't have, first of all, how do you become a U.S. citizen? All right. The way it's laid out in the law is you have to take an oath or affirmation in front of a judge, someone who can administer the oath or affirmation. So they don't have any evidence of you being a U.S. citizen, but they're trying to apply their rules and laws as a result. And then when you go in there, you are essentially binding yourself in a contract unless you somehow bring that to their attention that that's not the reason you're there. So those are things that you got to make clear when you go into these courts. Hey, listen, I'm not here to contract with you. I'm just here to make sure my rights are being protected, and that's what I'm here for. But if you don't bring that up, they operate under presumptions. You can't rebut the presumptions if you don't know what they are. These are things that people need to understand or comprehend, because I hate using the word understand, because that means something different in court. But you have to comprehend how these courts are working and why things are not going the way you want them to go. Basically, if you don't know that when you go in there, you're accepting a contract without your knowledge, you have no disclosure that it's a contract, they're going to presume that because you're in there trying to defend yourself or take care of your own stuff, they're still going to work against you unless you're clear in the beginning. This is why I'm here. I'm not here to contract with you. Yep. So that's what I wanted to try to bring a topic out. Maybe you guys can throw your thoughts and,
okay.
What things.
So let me go with that. This is exactly what I was just talking about. In your performing your administrative duties as part of your due process of law, you can't just sit back here on your haunches and go, that's wrong. You can't do that. That's wrong. That's wrong. The Constitution says this. When you haven't properly raised your hand to be heard, you're going to get railroaded. And this is what we're trying to teach you, okay? The first word you need to understand is in propria persona. This falls under your special appearance, the notice of special appearance. I can read it to you from my rules of procedure. It's there. I'm not lying to you. I'm not making this up. This isn't any sovereign citizen crap, okay? This is right in Black's Law Dictionary. Ignorance of the law is no excuse. You have to perform your administrative duties under the law. Now, they've made it a lot more difficult than it's supposed to be at the common law. You should be able to, at the common law, go in and see. There's another thing. The way things are actually supposed to be is our courts, our common law courts, are supposed to be at the post office. I know this might sound crazy, but if you read the Constitution, it says in Article 1, Section 8, that they are allowed to create post offices. Imagine that. That's where the courthouse is supposed to be, is at the post office, the people's court, okay? And then you're supposed to go to the church. You're already in church, right? Because we're supposed to be a religious country here. And you're supposed to try and resolve it through the church. And now your right to a trial by jury of your peers and from your vicinage, that's in the Virginia Declaration of Rights, June 12, 1776, okay? What you're supposed to do is you're supposed to pick out 25 people. And then you go in to the post office to have your trial by jury. And you select 12. And you put the 12 there. The 13th, it becomes the judge. Now, the judge is supposed to judge facts of law. That's their duty. They're a referee. That's it. You're supposed to have the right to present your case to the jury how you see fit. None of this crap about evidence and rules of evidence. We're talking the common law. We're supposed to talk commonly, just like we are right now. I should be able to go, well, so-and-so did this on this date at this time, and I have a witness to that event, okay? And then this happened, and this happened, and this happened, okay? And then the other side gets to talk, and they get to present their side, and the jury deliberates and makes, and in accordance to that particular one there, the right to a trial by jury in the Virginia Declaration of Rights, it specifically says, and to unanimous consent to find you guilty. That's the part of must convince them all beyond a reasonable doubt. And this is an ancient right. This actually is from back in England. This right is our right, an ancient right through history. But again, you have to read law, the history of law, and bills of rights. This Bill of Rights over here, the Virginia Declaration of Rights, is a Bill of Rights. So when we're talking constitutional law and it says bills of rights, that's plural, more than one. We have much more than just one Bill of Rights. There's the Magna Carta from 1215, 1225 revision, okay? We have the Virginia Declaration of Rights. We have the Declaration of Independence. We have the Declaration for Necessity of Taking Up Arms. We have to read this stuff so you know what your rights are and how to effectively claim those rights. You have to know where they are in law. And so one word is in propria persona. That's your notice of appearance and your affidavit of status. Your affidavit of status tells them that you are sui juris. Sui juris, again, is I'm of lawful age. I'm 21 years old. Okay. Now, the one Darren was just talking about there, it's called in personam. In personam is I'm here to claim my rights and defend my rights by law, by speaking the law. And I'm claiming you're depriving me of my rights. How do you plead? This is how you turn, no matter what case you're in, this is how you turn the case around and you become the moving party. You become the one that's claiming your rights being deprived and put them on the defense. And when you claim that, and you claim that the jurisdiction is not a lawful jurisdiction, because the right dictates what jurisdiction is proper before the court, and the subject matter that's supposed to be heard is based on the right, what right and how you deprived that right. Now, knowing all of this and filing your paperwork and notice to be heard, most of the time, your case will be dismissed before even going to court. When you claim there's no jurisdiction, personal jurisdiction, and they know they can't prove personal jurisdiction if they don't have an injured party. They don't have an affidavit of status. They don't have an affidavit of truth signed under penalty of perjury. That's part of due process, but you have to know that. Now, Chris, I'm going to let Chris on and see what you have to say.
Oh, man. We're back. Awesome.
We're here.
Okay. Well, I mean, you know, as far as I'm concerned, I think you pretty much covered it. I mean, there's not really much to add to that other than when you're looking at it from a procedural standpoint.
But that is the procedure.
Well, exactly my point. You know, and each state is a little different, right?
No, that's the common law.
No. I'm not talking about the common law. I'm talking about when you walk into court. Like, for example, you know, what Ohio calls a revised code, the Florida calls the Florida statutes, and so on and so forth. So that's the stuff you need to know when you walk into the court. Other than that, you know, each state has basically exactly the same thing, but they don't call it the same thing. And that's one of the problems we run into here on social media. So, like when I refer to something as Florida statute, blah, 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 somebody in Ohio says, well, that's what the hell is a statute? We have the Ohio Revised Code, and it's, believe it or not, it's something so simple does create conflict in there, whether we know it or not. But that's reality. It's just the way it's written.
Right. So here's the problem. You're trying to direct people to statutory law. And what I'm trying to teach is the common law. Okay?
Oh, don't shoot the messenger. That's what Florida calls it. So.
I don't care what the statute calls it. I don't care what the judicial branch calls it. These are our property. We own this. Nobody gets to dictate to us how to do this.
Correct.
Okay? This is the law.
Right.
In personam is how you make your claims. In propria persona is in my proper person as a human being, which means I have my own rights, and I'm objecting to the whatever jurisdiction it is you're claiming. Prove that you have jurisdiction, and they can't.
Exactly.
They don't know how to do this, and it's really simple. It's simple.
Right.
Screw the statutes. Screw the rules of procedure. Simplicity, common sense, common law, common sense.
Yes and no, because I mean, when you walk into the courtroom, you got to remember you're in the judge's house. So if you want the court to give you something, you got to show them the respect that their position is commensurate with. And if you do that, 99 times out of 100, they're going to look at you. They're going to look at the other party. They're going to look back at you and go, I ain't seeing what they're saying. And because, I mean, let's face it, most of what we deal with is, oh, he said this, or oh, he did that, or she said this, or she did that. And, if you walk in and you carry yourself like, this is your house, you're comfortable to be there, you're, showing the court its proper and due respect. You're not standing there waving, you're flailing your arms and acting like an idiot. Those are things that the court does recognize. They do. And a lot of people don't even realize it because when they walk in the door, they're walking in the door to do battle with their ex. They're not even paying attention to the judge. And that's where a lot of people fall short in court. They see their ex and they just go, rah! They go into that monster mode. You son of a, I'm going to blah, 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 blah. And the court's going, well, I see what's going on here. And what do you expect? So, you think it's basic, but it is. It's just that simple. Don't be cocky. Don't be arrogant. Just, good morning, pleasant day, blah, blah, blah. And show them their due respect. That's it.
And that is the biggest key right there, because you're actually asking the judge to give you relief to dismiss this for lack of jurisdiction. Mm-hmm. If you go in there acting like a jerk, you're not going to get anywhere.
Right.
But the thing is, what I'm trying to tell you is if you file this paperwork in the beginning of your case, the second you get your paperwork, you file your notice of special appearance in propria persona. Sui juris. This is in your affidavit of status. Okay. This is your actual identification. Driver's license, registration, proof of insurance. No. Here's my affidavit of status. This is my ID. Nowhere in law does it say I have to have a picture identification card issued by any state or foreign agent that says I have to have this to give to you. Show me the law that says that. And I said law, not statutory, not code, rules, regulations, and policies, because that's not law.
Right. Okay? Those are
you have to
guidance documents.
In its literal sense. You have to understand there is no statutory authority to tell you these things. The law says what it says. And we
just like Jeff Sessions said, just like we've said how many times.
Right.
So,
But that's our property. We own it.
Yeah.
And
that's right. That's mine. Who do you think you are coming in here to take my property? Right. Especially if you don't have a cause. Right.
And so that when you file this paperwork, okay, it puts them on notice that you're already not consenting to their jurisdiction. And most of the time, they will dismiss your case.
Oh,
Okay?
of course.
I'm not joking here, folks, because this is the common law. And when you know the common law, that means that you're bringing forth that I know what my rights are, and this is my property, and you're trespassing upon my property. And they're not going to want to have that heard. They will
Right.
dismiss it before you even show up to court for the first hearing. Okay? Now,
Well-
in the event they continue doing that and they deny you, deny or dismiss your motion for dismissal, okay? That's okay. That's okay. You still have remedy. You go to an appellate court. Not only do you file the appeal, but now that judge has created a right to a cause of action, an independent action under Title 42, Section 1983 for deprivation of rights. Okay? You've said I don't consent to this jurisdiction. I filed the proper paperwork here, and it's not that hard. Notice of appearance, your affidavit of status, and your motion for dismissal can be made orally if you even get to that part. But you can fill it out and go, well, I motion for dismissal for lack of jurisdiction, for failure to state a cause of action for which relief can be granted, and go, here you go, throw that all in there together. And they're going to look at that and go, unless, they think they're just going to railroad you and see how much you know and how to effectively defend your right to due process of law, or maybe they want to see you come in and argue your paperwork to see if you really know the law. And when the first time you go in there and you actually argue the law, and I mean argue because that's what you do. I'm not saying fight, but that's what we do in court. Or when
Come on, I want to fight it.
a debate, it's an argument. You argue your points of view.
Right.
And you have the right to claim your property and claim that another man is attempting to deprive you of your rights under the law, the common law. So when you do that, it puts them on notice that, maybe I ought to not deprive this man of his rights because he kind of sounds like he knows what he's talking about. And I don't want to lose my ass here. I don't want to end up in federal court under Title 42, Section 1983, 1985, 1986, dealing with tort claims under Title 18, Crimes and Punishments, and have the Attorney General throw my ass, prosecute me, and throw me in prison. I'm telling you, they know that stuff, and they know when you know. But if you don't know and they think they can get away with it, they're going to, because that's what they went to law school for. That's what they were trained to do, is to get away with it. All right, Darren?
Hey, I wanted to know, can you hear me first?
Yes.
Okay. I ran across a case law, and I can't, for the life of me, remember the case number right now, but it's recent, within the last 20 years, from the Supreme Court of the United States. It basically ordered all courts to follow this order, and the order of their cases was: first, jurisdiction must be proved; next, standing must be proved; then the merits of the case must be heard. If you hold the courts to their feet to the fire and make them prove the jurisdiction and prove the standing, if they can't do either one of them, they can't move to the merits. Okay, and you got to know what you're doing, and that's one of the things that a lot of people, when they go into courts, they don't know, they haven't dealt with the courts or whatever, but that's the kind of things that everybody in this country needs to learn: jurisdiction, how to challenge it, how to make them prove it, and standing, how to challenge it and make them prove it. Don't let them move on to the merits. Make them prove those two. If they can't prove either of those two, they don't have a case. They have to dismiss it. And you have to hold them to the fire on that. So maybe those are that case law. I'll try to find it and get it to you. I know I'll have to do it outside of here, but it's recent. It's in the 90s. I think it was 95 or 97. And it basically is an order to all U.S. courts. The jurisdiction has to be proved. then you standing, then you can move to the merits.
Yeah. Unfortunately, again, you're talking about stare decisis. You're talking about case law. That's not law.
Well, honestly, it isn't. It isn't law, but it is an order to the courts, and all the courts are U.S. courts.
Right. One thing I would be interested in finding in that case law is where, because see, again, this is findings of facts and points of authority. I guess it's called something else in other states, but see, in this case Darren's talking about, it should have a findings of facts and points of authority. Okay, so this order that was made should be based on law, and that's what the points of authority is going to be. Where in law does it say they can make this order? Because their decision, their ruling, their opinion is what they call it. This is where people get confused. An opinion of the court is not an opinion of the mind. Opinion of the court is based on law. That's why it's called finding of facts and points of authority. The points of authority being the Declaration of Independence, the Federalist Papers, the Magna Carta,
court case,
Virginia Declaration of what?
I think the court case was something like Steele versus Citizens for a Better Environment or something of that nature. That's one of the most recent ones I looked at, and I think it was one of them. But I'll look, and I can't remember where I found it even. But it's valid law. It hasn't been overturned, and the points or findings of fact and conclusions of law is another, like what you were just saying. Conclusions of findings of fact and conclusions of law is another way of saying the same thing.
Right. I like to use the actual legal terms so
Right.
that, you know, Darren and I have known each other, you know, through Facebook and conversations for over a year and a half, at least.
Oh yeah.
Coming up on 2 years now, I guess. So
Yeah, it probably is close to 2.
You know, these are the type of people I like having after show conversations with, or spending what little free time I have talking to, because he brings stuff to the table that I don't know. I'd never try to claim that I know everything. So just so people know, I talk to people like Darren, Chris, Crystal, Neely. You know, we are looking for people who are a little more on the professional side, both in their actions and their, you know, appearance, because we have to appear professional. We have to act professional so that we can actually get the attention of the people who make a difference in this country. You know, our representatives, these judges, again, going back to talking to these people. In order to talk to these people, you have to have the respect, just as a basic human being, you know, like you talk to your mom. So, you know, just talking to these people, showing them the law, they may not know. Okay. And until you tell them and you make your arguments, such as in propria persona, okay, in one's own proper person, it was formerly a rule of pleading that pleas to the jurisdiction of the court must be pled in propria persona, because if pleaded by an attorney, they admit the jurisdiction, as an attorney is an officer of the court, and he is presumed to plead after having obtained leave, which admits the jurisdiction. Speak pro se. Hello? There's a difference between pro se and in propria persona. Now, the next one was in personam, okay, which actually comes after sui juris. But sui juris in propria persona is in your notice of appearance. The sui juris and the in personam comes in your affidavit of status. So in personam, let's read that one. Against the person. Action seeking judgment against a person involving his personal rights and based on jurisdiction of his person, as distinguished from a judgment against a property, i.e. in rem, type of jurisdiction or power which a court may acquire over the defendant himself, or contrast to jurisdiction over his property. See also in personam jurisdiction, in rem jurisdiction in personam. Okay, so this is Latin, and I have a hard time with the English language, so I'm going to turn that one over to Chris about Latin.
Well, when you talk about Latin, Latin is where, for example, the best example I can use is the maxims of law, which are pretty much always quoted in Latin. It's funny that you're bringing that up, because I was looking for one that I have cited in various works. Basically, it says the practice of law is the practice of the court. Now, this is where we got into a little bit of a pissing contest between myself and the bar. And the bar says, well, we're the practice of the court. I said, no, you're not. Sims v. Ahern said that you cannot be, you can't license the practice of law. Right. You can't regulate the practice of law. The only ones who have discretion to change anything about the rules of the court is the Congress. The Congress lays out what the procedures are, right? This, rule 1, rule 2, rule 3, rule 4, and you go down the list, right?
Right.
Well, that's where the lawyers think they've got one up on you, because they can say, well, we're lawyers and we can make up whatever we want because we have exclusivity over prosecutorial discretion. Well, and unfortunately for all of them, that means we've only got one person to blame when we start talking about what the where the unjust enrichments are going, right? So that's a short list. And when we go in and say, right, when you go in and you say, according to this process, this RICO, right? Because that's a word everybody knows. This RICO, the thing that's the crime at the end of it that is written in law, I know that's your favorite phrase, is called an emolument, which is any advantage, profit, or gain received as a result of one's employment or holding of office, right? That's what the law says. So when you talk about a check and balance, okay, the check being, that's supposed to keep them from getting too big and too powerful. So when we come into, well, why the hell has nobody practiced it in 230 years? Well, we go back to the same thing. The answer's in the question. Because we fell asleep and we allowed this one entity to write the rules, right? 514 members of Congress, 509 of them are lawyers. And, that's our bad, right? So, now we got to wake up and go fix it. Well, that's what we're doing. We're waking up and going and fixing this shit. The good news is, all right. So because the way we've done it, it's been very effective. I mean, you do your reading, you do your research, you file the reports, you communicate properly with the people that can make that decision, right? And say, okay, look, here's what's going on. Here's what, this is what you've been doing. This is what the law says, which means you can't do what you're doing, basically.
That's the rule of law. It says correct. What it says. You can't do this.
Right. So when we come back to what Sessions just did, okay, he literally cut their feet right out from under them and said, guess what? Y'all can't do this. And we're not going to tell you where we got this information, but we found the word in law that says you can't do it because it creates an unjust enrichment, and then of course everybody says follow the money trail, right? Well, yeah. Fruits of a crime, unjust enrichments. Well, oh crap, emoluments. We're done now. So,
all right. So let's take another caller. We actually have a couple of them here. 9138. Welcome to the show. Who are we talking to?
I'm not sure if that's me or not, but
9138. You're the one talking.
Nah, that's me.
That's Darren?
okay.
Yeah,
Okay.
that's 9138. That's me. Hello?
Hello, who is me?
Danny. I just been sitting here listening.
Okay. 8401. Who we talking with? And welcome to the show.
This is Jeremy.
Hi, Jeremy. So, do you have a question for us tonight?
Yeah, actually, not sure if you guys are familiar with Michigan at all, but I'm actually been trying to chip away at my own front of the court, which is our family court agency, and been studying a few things about them. Well, in Michigan, they have what's called the Friend of the Court Act 294 of 1982. Well, in there, I know the wording in law is pretty powerful, correct?
Yes, sir.
Okay, so like every word, if it's defined by law, they have to abide by it, correct?
Yes, sir.
Okay, that was my understanding as well. Now, in this act, it has a brief description, and it just says, an act to revise and consolidate the laws relating to the Friend of the Court, blah, blah, blah. Well, in this part, it specifically states to establish a Friend of the Court Citizen Advisory Committee, which basically is a group of 9 people that basically oversee the complaints that come into the Front of the Court about the grievances that they have, if there's any kind of mistreatment from the workers. Now, this is the Title 4D program people in the state of Michigan. So they're the ones that collect all the money or whatever it is that they do with it. But anyways, I've been trying to get my county, which is Midland, to get their own CAC started, which I recently found out, well, not recently, but not too long ago, found out that they actually had one. Now, what I was under the impression is in Black's Law Dictionary, 9th edition, I do believe 9th edition, it specifically states establish is worded. And let's see if I can get back to it. I was looking up the impropriety persona and all that, but establish it basically it means more along the lines of a permanent kind of thing. And in both definitions, it describes permanency. You know, and is reference to a committee in the definition that you would, because there's 3 definitions that they give. The first 2 speak of more permanency, which is actually the second one speaks of the Article 3 courts, which were created and have not been terminated as far as I'm understanding. So they were created to be a permanent source of law or rule or whatever you want to call it. So once they establish, in my understanding is that in the law, it also states that each county may create one or may establish. It still uses the word establish, but it says may establish. Now, what I'm interpreting that as is that once they create one, they have to maintain it.
Right.
Now, there is rules of dismissing a committee. Now, if they created one, dismissed it not under the rules, did they go against their own thing? And is there anything I can do about it to kind of force their hand to recreate one?
I think that's a petition through state Congress, isn't it, Kirk? Congressional rules through committee?
I was going to say, wouldn't that be an articles of impeachment? No.
No, articles of impeachment would be to take action against the person who disbanded the committee. I'm talking about getting the committee back up and running again.
That would be the Board of Commissioners that did that.
Okay.
Right.
Did you petition the Michigan State Congress to find out what their take is on this?
No, I've actually am just getting going on a whole bunch of other stuff, but yeah, that's one of the things that I was kind of glancing over on how to go about doing that.
this is a good call, and I want to make sure that we want to spend some time with you. This is exactly the thing that I'm talking about.
Right.
Every branch of government has its own set of rules and procedures that you need to follow. 1, 2, 3, 4, 5, and if you follow those, and you file the paperwork, like Kirk says, in consistent with those rules, you can get what's called an audience before the congressional committee. Correct. So you petition for congressional time on the floor. Okay. I had the U.S. one around here somewhere. I'm not looking right at it now. It was actually my judicial report was, I referenced those codes to petition the U.S. Congress for time for that report to be heard and reviewed on the congressional floor. It turned out it was reviewed in committee, which is fine, but at least it was reviewed. So, because it didn't require my presence, everything was done. But in your case, you're requesting they take an action. Now, the action you're taking is you want to follow up with the friend of the court committee, right? Or is that what it's called?
It's a citizen advisory committee.
Citizen advisory committee. Okay.
Yeah, it's called the friend of the court citizen advisory committee.
Okay, so you've got documentation that shows that this thing actually did exist, and et cetera. Et cetera. There's a paper trail a mile long. Okay, good. Now, what you want to do is you want to take.
I'm sorry. Go ahead.
Yeah, what you want to do is you want to take that document and find out where the record of that document is, because that will be filed in the court of public record under a specific directory. So as long as you can find out what the identifying numbers are of that specific entity, you can take and request the Congress review that entire mechanism, and you want to basically reinstate it. You want to find out, is there funding available for it? If so, how much? Who's the treasurer? Blah, 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 blah. And they will send you a list of names of everybody that was ever associated with that committee. And then you can start to follow up with those people, and then you can compile if you get what you need, great. If you don't, you compile a report, a log. I talked to so-and-so, so-and-so, and so-and-so, and, John Jones was deceased, but Jane Jones says, this was delegated to so-and-so, and you compile that report and you send that back to the committee for review to basically update the record. And you can introduce yourself if you have credentials, like, for example, my favorite one a lot of people use, believe it or not, is a notary public. A notary public is a sworn officer of your state. So under oath, you can use your notary commission number and, go through that process. But what you need to do is you need to look up the Michigan State congressional process and go through that. That would be the best advice I could give you. I'm sure it is. But you can break it up. Okay. So, for example, you're not going to go to the Commerce Commission for the thing you're talking about. So, you can kind of break it down and find the PDF of and then search the PDF for keywords. Okay. That should take you pretty much right to the sections that are relative and the sections and rules that you'll cite when you're drafting your documents.
All right.
Pretty cool.
It should be lots of fun.
Yeah, it is. Get a big bottle of Tylenol, man. You're going to need it.
Yeah, I'm still learning the appeals process. I haven't even mastered that yet. So I can imagine that's going to be fun.
Same thing, same process. So if you want a habeas brief, for example, you go to the appellant rules, pull that up, download the PDF, search the PDF for habeas. Oh, there it is. Where are the rules for that? There it is. Rule, blah, 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 blah. And you go down the list.
Question. Here's another quick question.
Hold
Can
on.
you skip
Hold on. So part of opening up that new committee, where Chris Hallett was talking about going in and finding out who the old commissioners were and all that stuff, and you're getting a hold of
I already got all that.
Okay. Try to get a hold of the old bylaws, because in order for the committee to operate, you have to have your bylaws. So that's a lot of work creating all your bylaws. And if you can snag a hold of the bylaws that were already approved before to run that committee and basically just start back up, that puts things on a faster track to getting things going. And the other thing, this was a great question, so I'm kind of interested in your next one. Committees, this is oversight. This is part of our, all political power inherent in the people. We have the right to alter, reform, or abolish anything at any time, however we see fit, because we're self-governed. So these committees, this is a great idea to get these committees going. And I thought about doing a committee of safety, but after looking into it, Texas was the last one that had one, and it's been so freaking long. It'd be a lot of work to try and do a committee of safety.
Well,
but
go ahead. Sorry.
Go ahead with your next question.
Well, I was actually going to add on to what I found out about with Michigan CAC, which I call it a CAC. It's kind of funny, CAC at the FOC.
Right.
But anyways, the fuck the FOC or whatever. But that's what they say. I don't know. That's just something I heard.
But like anyways, the FAQ, the FAQs.
Yeah. That's pretty much what they do. But anyways, along with the Michigan CACs, I've noticed that other states have similar organizations with similar rules. But they're not instated, or they've been instated at one point in time, but they've been disbanded or whatever. And you said something about the rules and everything like that. I already have the bylaws and everything like that they were already supposed to follow. Mm-hmm. And like I said at the beginning, that there was rules about disbanding a committee or a committee member. And the reason they said they stopped it was for lack of participation. Well, in that case, it actually calls for a re-election of committee members, not a disbandment. So,
okay.
I can understand that and make it a little bit easier as far as, well, listen, they went against their own bylaws when they disbanded it to begin with, So, right. I was more along the lines of thinking that it would be a little easier just taking them to court. So I don't know if you'd be able to sue them, if you'd be able to sue the county, the board of commissioners, or exactly where you would be able to go, because I know you can sue a government for less than monetary means, which you can enforce.
That's kind of the long way around. I would say that's the long way around. That's why I said I think if you just go around the court, go straight to the congressional committee, and you just say to you just basically say to the state Congress, look, I think there was an error here. I'd like to pick up where we left off. What do you need from me to do that? Right. Mm-hmm. And you can get appointment through the state. That's how I opened E-Clause, my loss prevention practice. I just went right around the corner. I said, you know what? I'm not going to have this argument with you. You don't want to talk about it. I don't want to talk about it. Good. I'm going to go straight to Congress, which is what I did. Next thing I know, E-Clause is built. It's the only one of its kind in the country. So now I'm having some fun with it.
Yeah.
Right?
Ever since I started, go ahead, sorry.
Crystal on with this.
What's that now? Sorry, I didn't quite hear it.
There she is, 7731. I knew it. I got it memorized.
Yep. It's about time too.
Well, and you dropped out and came back. Well, not all of it.
Well,
and I was actually interested in hearing all that, because I have done some research on committees of safety. And when I got digging into it, I'm like, man, that's an awful lot of work. I can't do this all by myself. And so I move on to the next thing.
Mm-hmm.
So I was really interested in actually listening to that, because see, that's part of another thing that I'm about, is I shut up and listen when it's something that I don't fully understand or know about, because you can't talk and listen at the same time.
True that.
Yeah, that's true. So
That's why you have 2 ears and 1 mouth.
Well, rabbits have
twice as much listening.
You've been talking to my mom again, haven't you, Crystal? That's her favorite line.
I have. I'm a mom. What do I say?
50 years old, and she still hits me with that one. You have 2 ears and 1 mouth. Shut up and listen. Yes, Mom. Sorry.
Well, if you have 2 ears,
Amen.
it goes in one side and goes out the other.
Right.
Right.
Oh, Kirk, I got to tell you, thanks for explaining the difference between pro se and pro per. A lot of people, if they Google it or something, it usually pops up pro se, which don't give you any kind of definition of what persona is.
Yeah, they try to force everybody into pro se, and see this there again.
Well, that's acting as an attorney. That's you acting as an attorney versus you acting as an individual.
Well,
that's what I take pro se as, pro se versus pro per.
Be a proper person, but not in your proper person.
Yeah.
In propria persona.
You're speaking on your
proper person.
And if you're going to act with counsel or be co-counsel with an attorney, then you have to file it pro per versus pro se.
Right.
Yeah. Yep.
You know, it's funny because when I first started doing this, I thought, ooh, pro se. That's got me written all over it, because I don't know how to shut the hell up. Especially when I get into an argument.
Right. So there was a question about fraud here, and I need to try and see if I can back up. That I wanted to try. I think it was Richard Provost. He was talking about what I have seen. Taking West Virginia, for example, they're using common fraud to escape liability and lawsuits. Statutes of limitations is 2 years on fraud. Okay.
Not in the federal.
This is what happened back in the day, and this is what they do. They go through and they try to clean up stuff. See, fraud is actually at the common law, and because fraud is unjust, nothing can be left unjust. So there was no statute of limitations on fraud, and what they did is they consolidated the statutes on fraud with clerical errors and mistakes under Rule 60. But if you read the Federal Rules of Civil Procedure and read Federal Rule 60, now there's A, B, C, D, delta, not Bravo, delta, D. Okay? D is an independent action. So in the middle of your case, you discover that there's fraud, or you know that there's fraud, and you've argued that it's fraud right there. Okay. Let's go.
Rules of evidence, that's called poison fruit, by the way.
Past 2 years. Okay, let's say you find it past 2 years. As an independent action, you can take it, and what I mean by independent action is a brand new case. It's all brand new. It has nothing to do with your case that you have now, other than, you know what? There's a statute of limitations under this jurisdiction to hear it here. So the rule actually provides the independent action for fraud, because again, fraud is unjust. So nothing, balance beam justice. Okay. No matter how long that fraud has been, it still has to be fixed, because that's a moral wrong. That's what justice is about. Virtue. It must be virtuous within what is just. So if you find your fraud, oh, well, the statutes over here say, well, take it to federal court under Rule 60, or you can even go to your state court. If you're in New York, forget it. I learned tonight, that's a total mess over there. Get the heck out of there. Holy, yeah. Sorry about New York. Man, I wouldn't want to live there for that.
Oh yeah, dude, I'm making the sign of the cross about that one. Holy crap.
That one's off of my list of states to visit. I don't even want to cross paths with that corrupt court system.
Yeah, screw that.
So,
that's one of those go there on vacation, leave on probation states.
Right?
Yeah. So, yeah, the fraud part of things as an independent action, new case, and take it that route. Either you can do your state court or you can take it to federal. Federal might kick you out, probably because they don't really have jurisdiction over that, unless you're doing it under a Title 42 civil rights or any other cause of action that can only, the remedy is only in federal court. You know, this is where the states have kind of chopped their hands when they abolished the suits at law and suits of equity. That's in my organic constitution. I found my organic constitution. When I found it, I printed it out because for the life of me, I can't even remember where I found it. When I found it. So
the organic one, is that the special organic section in the grocery store?
Sorry. Goddamn coffee beans.
Right.
Is it right next to the meat department?
You did not just go there.
No, Montgomery Ward versus Eugene Glasser. So hopefully I answered at least most part of that fraud part is, you know, look at your federal rules of civil procedure under 60. In Idaho, our own rules of civil procedure is exactly Rule 60. Almost word for word in that rule says exactly the same thing as the federal rule of civil procedure. Now, another thing, Rule 12. Oh my gosh, I just looked at it today. Rule of procedure. Actually, I still have it. That rule says from Fran's show, which I never even talked about earlier today. I had it pulled up. Let me see. Right here. Rule 12. Defenses and objections, when and how presented. Motion for judgment on pleadings. Consolidating motions. Waiving defenses. Hearings before trial. Okay, so let's scroll down here to how to present defenses. Every defense in law or fact to a claim for relief in any pleading, whether a claim, counterclaim, cross-claim, third-party claim, must be asserted in responsive pleading if one is required. But a party may assert the following defenses by motion. So at any time, number one, lack of subject matter jurisdiction. So Rule 12b-1 would be the motion for dismissal for lack of subject matter jurisdiction. That's how that would lay out in your motion. Number two, lack of personal jurisdiction. Now, this is my own Idaho rules of civil procedure. Now, like I said, this Rule 12 is almost exactly verbatim like the federal rules. Number three, improper venue. Number four, insufficient process. Number five, insufficient service of process. Failure to state a claim upon which relief can be granted. Number seven, failure to join a party under Rule 19. So I would have to go to Rule 19 to understand how to join a party to the case in a timely manner. Number eight, another action pending between the same parties for the same cause. So if you have this goes back to could go back to that res judicata kinda, where you have another case and somebody else has tried to bring another case on the same cause. You can't have two cases hearing the same thing. You have to get one of them dismissed and get a final judgment on it, and then you can start another one, unless it's for fraud as an independent action.
Right.
Because the cause is for fraud, not for the original cause that caused the fraud. It's bringing
Right.
the fraud. So let's back up to lack of that subject matter jurisdiction. What's subject matter? The subject that's actually in debate. That's the subject matter. So marriage or parental rights. Okay, where does parental rights come from in law? The law of nature, protected by the 9th Amendment. That means it's at the common law. So the subject matter jurisdiction, this court lacks to hear, the ability to hear this subject matter because it is an unlawful jurisdiction, because it does not have the jurisdiction to hear common law hearings, pleadings, these rights. These rights.
But it does under the 14th Amendment to hear it.
No. Stop it. You know how I feel.
I know you really hate the 14th Amendment, but they will hear the 14th Amendment in the federal courts.
We're not talking about federal court. I'm talking about Idaho rules of civil procedure right now.
Oh, sorry.
Although they're the same, it's pretty close to the same exact, almost exactly the same exact wording and even layout. It's crazy. Imagine that. So the subject matter is, parental rights. This court lacks subject matter jurisdiction because this is called family court, and the right in law comes from the common law. What I mean by that is because where the right comes from, it has nothing to do with the establishment, support, or management of a government. So it has to be heard at the common law. The common law rules apply. But I'll warn you, the common law is ruthless. So not just specifically parental rights. And Chris knows, I don't want Chris to even put this out there because it will really cause some problems. But at the common law, it can be ruthless, I'm telling you. So if you want to start going the common law route, be careful because you could find yourself in trouble, or the other way is you really slam somebody bad. So
yeah, pistols at 10 paces kind of bad.
Right. So perfect example, a suit at law. That's what Title 42 is. It's a suit at law.
Right.
The federal courts are the only ones still operating somewhat in accordance with the Constitution, Article 3, Section 2. Okay, lack of personal jurisdiction. We went over that here just a little bit ago, that in personam jurisdiction. That's the personal jurisdiction. Does the court actually have personal jurisdiction over you as the man? So when you look at your paperwork and your name's written in all capital letters, that's not you.
You're an entity.
That is an artificial person. A corporation.
Wait. Go back and just define that. When it's in all capitals, it's what?
You're an entity, a business.
So if you're lowercase, are you a person?
It's an artificial person.
With first letter uppercase, uppercase, rest lowercase, then you're deemed a person.
Right. So what we're actually talking about here is
you took English class, Crystal.
Yeah, I was going to say.
I know I did, but I failed it.
That's why your social security card, everything, birth certificate, all has it.
Yeah.
Okay, so if we sign the paperwork or documents in the court, do not capitalize a person's name? Or all caps? I did not know that.
Well, see, it's
That's
hard
where it
to
gets tricky.
Either way how you want to do it, but what I'm trying to tell you right here is what this personal jurisdiction applies to. When you look at your paperwork and your name is in all capital letters, but you're not a corporation, let's say it's McDonald's. Of course, McDonald's is a corporation, okay? But you as a person, in your proper person, in propria persona, in personam claiming your rights, okay, they don't have personal jurisdiction. That name is not you. You're not an artificial person. Look, I'm flesh and blood here. I'm a human being, living creation of God. I can't be an artificial person.
And to that,
that's lack of personal jurisdiction.
Right. And to that, I'm going to add to that, Kirk, because the maxim of law I'm staring at right now says,
awesome.
When you're talking about,
I can't be.
What's our favorite thing? Perjury. So basically somebody's deceiving the court. There's a maxim of law for that. The maxim of law clearly states the laws help persons, remember we were just talking about that, who have been deceived, not those doing the deceiving. So if you're asking the court for help on perjury, and you can definitely prove it, the applicable maxim of law that gives the judge in the court the ability to act on your behalf is the laws help the persons who have been deceived, not those deceiving. It's that simple. So if you want to know how to apply a maxim of law, that's a perfect example of how to apply a maxim of law. So if that's, as I'm sure there's been several questions about that. So I want to make sure I covered that.
So Fernando Cook out there, can you unblock me? Because you and I kind of got in a discussion one time, and you thought I was full of shit, and you blocked me. But now you're on my shows, and you're, agreeing with some of the stuff I'm saying and posting some of the same stuff that I already know. But I would like to welcome you back into the fold if you can find it in your heart to forgive me whatever it is that I upset you on that made you block me. That's up to you. But I do see you on my shows commenting, so yeah, I just wanted to put that out. I couldn't get a hold of you any other way. So, and I see you're commenting, so I'm talking to you as best I can. So personal jurisdiction, that's it right there. If your name is in all capital letters and you don't want to consent to that, this is what you have to file. Follow the rules of procedure. Rule 12B2, at least in my rules of procedure, but I'm showing you how to do this.
So one question about that. If you state
this kind of show what I'm talking about.
If you state that on record that you're a man, flesh and blood, born of the land, God's land, and you officially state that to the judge on record, does that account for anything, or do you have to still file it in a motion? Okay. Stating not necessarily speaking on sovereignty or anything like that, because I know that's more of a dangerous ground to tread than anything.
Right. But I defeat that sovereignty trap, because we have an Idaho code that says it's Title 74, Section 201, that specifically says the people of the state of Idaho do not yield their sovereignty to the agency so created. So how do you deal with that?
Yeah, see, I don't know if Michigan has anything like that, but
every state will have one. That's in your ethics and government. I actually took some time and started to go through a lot of the statutes. Through states, I found Washington. Washington has a pretty good one. Oregon is better than Idaho's. I found Montana's, Nevada's, Utah's. Idaho's kind of short and sweet. But I'll tell you, if you find that ethics and government right there, that people don't yield their sovereignty, it's wrong.
One thing I did find out about that with speeding tickets or whatnot, if you claim that, no victim, no crime, and just ask them, because it's usually the people or the state of Michigan versus whatever, and you just ask them, well, bring the injured party forward, so they can lay claim against me, dude. And they ain't never anything ever done. They always try to knock them down, and sooner or later they get dismissed after second appearance. Because they don't make money off that. So
right. So John Patton, they're going to order a psych eval. Okay. So here's how to deal with that. You don't have to prove the negative. You only have to prove a positive. The law says, okay, well, where does that say that? Okay, it says it right here. If you can show what the law says, then the judge can act on that. Now, when they say, well, they're going to try and order a psych eval, they can try on it. Show me in the law, Judge, I'm objecting. I don't consent. Show me in the law where it's not in your statutes, codes, rules, regulations, and policies.
Did you go
In
through PayPal
law.
to pay for it?
And that's that's what you have.
Isn't there an ethics rule? Sorry, sorry. Go ahead.
Like Crystal was talking in the background. She didn't mute herself, so we were hearing.
Sorry.
I'm trying to run the board, read, and look at everything all at once. So forgive me. I can multitask pretty good most of the time. What did you have to say there, Danny?
It's Jeremy, but
Jeremy.
Isn't there like an ethics code that through the Bar Association or even the Judges Association, and I almost guarantee it's in every state that there's an ethics code where if a judge or lawyer knows, or an attorney or whatever, knows of a case law, a case study or whatever, and knows of it, and downright knows of it, and basically doesn't, even under the mention, like, well, say, there a case law that so-and-so did so-and-so, and the same exact situation as this, and, if they even give any kind of reference to that law and they know about it, there is sorry, I'm getting tongue twisted here. I'm trying to look it up right now. But there's repercussions that they can face, for going against judicial conduct.
Yeah, you have judicial canon laws, and then you have the code of ethics. Every state will have.
So I was talking more canon, but yeah, go ahead.
Yeah, judicial canon is for the judicial branch, and the code of ethics is supposed to be for the bar. It's the bar code of ethics. So like with my judge, I started claiming that my judge or my paid attorney failed to defend and make an objection to appointing this parenting coordinator. I said, well, appointing a parenting coordinator has to do with divorce actions. Title 32, Chapter 7, the title of it, subject matter, is divorce actions. I'm like, how do we have an action for divorce here to appoint a parenting coordinator when there's never been a marriage contract that binds either one of us to this jurisdiction? And the judge is like, you're right. I want to hear this. I want a motion to vacate all orders for fraud, Your Honor. That's fraud upon the court. And she's like, well, he told me, it's like, well, you can actually file a complaint against your attorney. In fact, you could file a complaint against both attorneys because, like I said, it's all over the paperwork saying that neither one of us were never married. We were never married. So, it's
when you're in marriage court.
And her attorney should already know that we were never married.
Yeah.
So why was he bringing a motion to amend from a mediator to a parenting coordinator?
It's funny. I actually got into a conversation like that once with an attorney and said, I just flat out asked him, dude, did you go to law school? And if so, did you pass? Because if you did, you should get your money back. If you can't put those two things together, then, somebody's giving you some wrong information somewhere, brother, because that's not how it's done, period.
Right. Man, we've got like at least two other callers here backed up, and we're already pretty much out of time for the night. So I apologize that we didn't get to more of the callers here, but this is our first time doing the call-in show. This is just strictly a call-in show on Wednesday nights now. Kirk and Chris and Ted's excellent adventure.
It's our lie, and we're telling it any way we want.
Right. Thank you, Fernando, for unblocking me. And send me a friend request if you would, please.
Yes, mend those fences. That's what we're about. That's what we're going to do.
For knowledgeable people.
Yes.
And I know that you're a knowledgeable guy, but you and I think, crossed somewhere somehow, and I honestly don't remember what it was about.
He likes to talk
and you got mad at me and just said, like I didn't know what I was talking about or something, and I run in that all the time, especially when you're typing online. You can't quite hear the tone of voice in words. So if you watch my shows and then go and read what I'm saying and take in the tone of voice and how I talk, that helps a lot, because that's the problem with text is, whoa, why are you so pissed at me?
Yeah.
All caps. You don't yell at me, man. I didn't do it. I promise. I swear.
Why are you so pissed at me? Why are you pissed at me? What did I do wrong? Why are you pissed at me? What are you talking about?
Dude, that was like autocorrect. My bad.
So, well, we might have an after show here, but we do want to thank you for tuning in tonight. And this is going to be a regular thing here. So Monday nights, I want people to understand that it's law. We're going to be teaching law for dummies, those mannequins over there.
Dummies like me.
all of us, okay? I don't know everything. Chris don't know everything. You don't know everything. She don't know everything. Well, let's come together. Let's come together and share what we do. We will accomplish so much more when we work together. And the more brains, the more brain power we have, the better off we're going to be. Trust me. And I know most of you know this. So even if you have problems with certain different people that are here right now, put your personal issues to the side and let's focus on unity. Let's focus on the goal of liberty, because that's what our founders focused on. Clear back in 1215, from the English crown, the separation was a religious separation based on liberty. We want freedom to do whatever we want to do. Okay? It was a separation from the Roman Catholic Church. That's where it all started.
Well,
religious separation in 1215, in the Great Charter of Liberty. So if we can find, we all want liberty, right? We all want to be free from any kind of government interference, because that's why we have a guaranteed, we're supposed to have guaranteed, Article 4, Section 4, Republican form of government. That's where we are self-governed. We get to dictate what the law says. And we carry the law in our property. We already dictated what the law says. It's called common law. It's common to all. So pick some of that up. Start reading it. Understand what your rights are. If you got questions, that's what this night is going to be for. Unless on Monday nights, we're talking a specific part of the law and you have an actual question regarding what we're talking about, the subject matter right there, please call in, or we try to watch it, but see, I keep getting this crap. My phone just blanks out.
Yeah.
Or it says close app is closed.
Yeah.
And
I know. Same here. Yep.
All right. Well, thanks for having me, guys. Thanks for listening.
Thanks for calling in. Looking forward to doing it again.
Yeah, Chris, I'll be getting a hold of you and asking you a few more questions about that.
Stay on.
So
absolutely, yeah.
Right.
I can help you navigate Congress. I've actually learned how to do that fairly well.
Stay on
right,
here
cool.
on the call, because we'll shut down on Facebook and YouTube and Twitter and all that. But this particular part right here that you're calling into is what we call the after show. So
we talk amongst ourselves.
Go ahead, Ted.
I said we just talk amongst ourselves.
I suppose I have to unmute him.
Program.
Poor Ted.
Well, no, it doesn't matter, since I'm broadcasting it. Everybody out there can hear me. I can talk over all of you if I wanted to.
Right.
You're the man.
So I do want
to
thank everybody for tuning in to our Kurt, Chris, and Ted's excellent adventure for Wednesday nights.
Love it.
Which was Ted's idea. About 2 weeks ago, he did a call-in show and had fairly good success with it, and we see the need. Okay,
yep.
We see the need out there for this type of call-in stuff.
Yeah.
But we also, in my vision, from almost 2 years ago now, is to start teaching the people what this actually says. That's what Monday nights are going to be about. Wednesdays are going to be the call-in show.
Beautiful.
So we're trying to meet the needs of the people. Do what we can.
I am going to have a Thursday night show, but my guest wanted to wait for her attorney to be available. So I'm just going to have a show tomorrow night about the event I'm hosting in New Hampshire on the 14th of March, the first annual New Hampshire Christmas Suffrage March. We'll be singing Christmas carols that I alter to apply to family law. A couple
Scared of
them.
you.
It's gonna be freaking awesome. Wicked freaking awesome. To say it in New Hampshire.
Love it.
Love that. I love that. Wicked love that.
Well, much love out there for all of you out there doing the same thing we're doing, trying to educate the people, trying to help people where we can. Get local. Start talking with your representatives.
Absolutely. And as far as learning how to navigate those those entities, what one of us doesn't know, the other one can sure pick up the slack. So, and this goes for moms as well as dads. So,
Right.
we're an equal opportunity
Yeah.
teacher here.
You're
And
an
as far
American.
as,
That's all I
you know,
care.
yeah, exactly.
We have people from around the world.
Yeah, I enjoy helping moms, believe it or not, more than dads. Moms are easier to work with than dads. As scary as that
Not
sounds,
to poke
but it's
fun
true.
at it. Not to poke fun at it, but we the people don't have a gender.
Good point.
Oh no, God, not another one.
No, definitely no, not another one. No, definitely not.
The civil
Just saying,
rights
as we as
movement.
people, we're everybody has rights.
That's
The
right.
civil rights
That's
movement would not have
You
been
know,
successful if
regardless.
black men
No,
said black
it don't
women
matter if
shouldn't have the
you can
same.
be as confused as you want.
Male, only white males
Mm.
have rights.
Oh no, rabbit.
And what's crazy?
No.
Too, if you read
You're a white
Bible-
male. I know you know
It
that
says-
ain't right.
I'm saying in the history. That's how it originally was.
Yeah, that's what the history
Yeah.
says. But I think we hit puberty somewhere in there. I don't remember when it was, but I do remember
Yeah.
the pair dropped at some point. But
As a white male right now, we're probably one of the most hated species out there right now. White male, and that's pretty sad.
yeah. Well,
We got so many people that walk around like ashamed to be white anymore, and it's like, why are you ashamed of what God made you?
yeah,
I mean,
I'm not.
I'm definitely not.
Hell no.
But shit, I mean, my grandfather's Mexican. Okay, my grandfather's Mexican. My my grandmother's Greek. I'm a Heinz 57. So yeah, I can't hate anybody.
I'm actually related to Princess Di, so I have some serious heritage.
Nice.
That was a beautiful woman right there. That was a
she
beautiful
was.
woman right there. Heart, body, and soul.
Mm-hmm. By where I get it from.
So,
It's in my
Yeah.
family blood. I'm not kidding. My grandmother
Yeah.
did that. She's got all that genealogy stuff. She did that quite a few years ago. She's like, we're related to Princess Di. I'm like, what?
Interesting.
John Pat
Yeah.
says my blood's.
Hey, it's in my blood. It's in my DNA.
Dinner.
well, the Redolins in my family doesn't mean I'm a singer.
Did you kill that yet,
I
Ted?
sound like
No, we're still live. You.
Oh,
we're still alive. There
All
you
right,
go.
everybody. Have a great night. Love you. Thanks for watching the first Kirk, Chris, and Ted's Excellent Adventure Call-In Show live.
Love you guys. Have a good night.
Have a good night.